The future of artificial intelligence hangs in the balance as a legal battle between authors and AI developers threatens to reshape the landscape of innovation. But here's where it gets controversial. Silicon Valley and digital rights groups are rallying behind Anthropic, an AI company fighting a ruling that could set a dangerous precedent for the entire industry. This case isn't just about copyright infringement. It's about whether AI can learn from existing works without stifling creativity and progress. Anthropic finds itself at the center of a storm after three authors, Andrea Bartz, Charles Graeber, and Kirk Wallace Johnson, sued the company, claiming its chatbot Claude was trained on their books without permission. The ruling by U.S. District Court Judge William Alsup in the Northern District of California has sparked intense debate. While Alsup acknowledged that Anthropic's use of purchased books for training was exceedingly transformative and protected by fair use, he drew the line at books downloaded from piracy sites. And this is the part most people miss. Alsup's decision to allow a class action lawsuit on behalf of millions of copyright owners could unleash a tidal wave of litigation, potentially costing Anthropic and other AI developers hundreds of billions of dollars in damages. Tech industry group NetChoice, whose members include Google and Meta, warns that such a ruling risks creating a template for similar massive copyright classes against generative AI developers. They argue that this could freeze innovation in a field that relies on learning from vast datasets. Should AI be allowed to learn from copyrighted material if it transforms that content into something entirely new? Or does this cross a line that undermines creators' rights? Anthropic is fighting back, urging an immediate appeal of Alsup's ruling and challenging the certification of a class that could include up to 7 million claimants. The company argues that the case raises individualized issues that cannot be fairly resolved in a class action framework. On Thursday, several outside groups, including NetChoice, the Electronic Frontier Foundation, and Public Knowledge, filed friend of the court briefs in support of Anthropic, highlighting the unresolved constitutional questions surrounding AI and copyright. The Electronic Frontier Foundation and Public Knowledge went further, warning that Alsup's decision could create a death knell scenario, forcing AI companies to settle rather than face crippling damages. This, they argue, would leave critical questions about AI and copyright unresolved. But here's the counterpoint. If AI companies can freely use copyrighted works without permission, what happens to the value of original creation? Doesn't this undermine the very foundation of intellectual property? As the authors prepare to respond by August 14th, the stakes couldn't be higher. This case isn't just about Anthropic. It's about the future of AI and the balance between innovation and creators' rights. What do you think? Is AI's use of copyrighted material fair? Or does it overstep boundaries? Let's spark a conversation in the comments. Your perspective could shape how we think about this pivotal moment in tech history.